DOJ's responses in very short order. It's my hope, so I thank you for that. It's my hope that under your leadership, the Department will continue to respond expeditiously to this year's questions for the records. And one of the things I remember from the conversation we had before your confirmation was your commitment to work closely with Congress, and this subcommittee in particular, to have an open dialogue and a transparent conversation. And your answer to those questions on the record will be and continue to be appreciated. I would add an additional thank you, which is thank you for your presence here today. This testimony is important, and I now recognize the ranking member, Senator Shaheen.
Well, thank you, Mr. Chairman. Good morning, Attorney General Barr. Thank you for appearing before this subcommittee. I share the Chairman's view that we want to try and focus mostly on your budget, but I have to begin with two concerns that I have about actions that you and the Justice Department have taken. First, I saw your testimony yesterday, and I still do have questions on the special counsel's report, as I believe this report has serious national security implications. We know that Russia interfered in our election. We know that the special counsel has brought nearly 200 charges against 34 individuals and 3 companies, including 6 former Trump officials and 26 Russian nationals. I am concerned by recent media reports that those working on the special counsel's team believe your summary to Congress glossed over the severity of the damaging actions of those in the White House, including the President. The American people should be allowed to see the report in its entirety so they can make their own judgments about its content. I am also troubled by the Department's recent decision to support a district court decision that would completely invalidate the Affordable Care Act. I have questions for you as to why this decision was made. This recent action by the Department will put millions of Americans, including 118,000 Granite Staters, at risk of being unable to afford or simply not have access to their current health care coverage. The loss of protections for pre-existing conditions and soaring prescription drug costs for seniors will affect thousands. And this includes vulnerable Americans like a young boy named Seth from Northfield, New Hampshire. He lives with hemophilia. It's a disease that requires hundreds of thousands of dollars of medication and treatment costs every month. Before the Affordable Care Act, Seth's father would have to change jobs because Seth's medical costs were constantly running up against the family's annual limits on the dollar value of insurance coverage. Children like Seth, those living with pre-existing conditions, stand to lose the most if the Affordable Care Act is wiped out. They could be denied insurance coverage because of their medical condition, and insurers would be able to jack up costs and cut off coverage after medical bills reach an arbitrary threshold. I believe we need to work together, Republicans and Democrats, to improve the health care law, not unravel it. And I hope that we will be able to do that in the coming months and years. I do acknowledge, as I said, that you are here today in your role as Attorney General to explain the Department's fiscal year 20 budget request. The complex and often difficult work of the Department is vast, ranging from national security investigations to operating a national prison system to management of billions in grants to state and local entities. Yet, in fiscal year 2020, the Department has requested nearly 2% less funding for its missions than the level provided in the omnibus we passed last month. The Bureau of Prisons is a large part of this reduction, a cut of $188 million below what we just enacted in fiscal year 19. It's disconcerting that the Department would slash the budget for BOP in light of our direction in Congress to continue hiring, particularly so as not to rely on augmentation, which is the dangerous practice of using administrative staff, like teachers and counselors, as correctional officers, including expanding programming for inmates, cutting programming for inmates at facilities across the country, including at FCI Berlin in my home state of New Hampshire. It's also troubling that the Department seems to have forgotten about meeting the requirements for prisoner re-entry as part of the recently passed First Step Act. There's only $14 million requested with little detail as to how you plan to use that money, when $75 million has been authorized for this effort. I was also surprised about drastic reductions and eliminations proposed for Justice Department grant programs, including those to help our communities fight opioids. I am deeply concerned that this budget request cuts nearly $100 million in funding that we just provided for justice grant programs to help communities respond to the opioid crisis with a balance of enforcement, treatment, and prevention programs. I'm interested to hear your reasons why your FY20 budget dramatically reduces this critical funding and even eliminates key programs like COPS, anti-heroin task forces, which we provided $32 million to cover, and mentoring programs for youth who are directly affected by the toll opioids have had on their families and communities. We funded that at $15 million. We see this very dramatically in New Hampshire, where, as I think we discussed previously, we have the third highest overdose death rate in the country. I understand that there's more demand on these programs than even we in Congress have appropriated. So what I don't understand is why we're talking about eliminating them. In closing, I want to echo the appreciation that was expressed by Chairman Moran for the 112 career employees at the Department of Justice. They work very hard to keep Americans safe from crime and terrorism, and especially during the government shutdown, they worked without any guarantee that they would be paid. So I know that I speak for everybody on this committee in thanking them for their service. I look forward to your testimony today, Mr. Attorney General.
Before we turn to the Attorney General for his remarks, I'd recognize the Vice Chairman of the full committee, Senator Leahy, for any comments or opening statement he'd like to make.
No, thank you, Mr. Chairman. And I agree with both you and Senator Shaheen and the 112,000 who kept on working during the shutdown. It went on for 35 days. I remember very well the day it ended when 4 of us met in my office, Senator Shelby, myself, Congresswoman Lowy, and Congresswoman Granger, and we made an agreement on the appropriations, and fortunately Republicans and Democrats joined with us on it and passed. The President vetoed the first one because it gave him only $1.6 billion for the wall. The agreement that we agreed to gave $1.3 billion, but he accepted that, and I thought it was about time we got back to work. Now, there are a lot of pressing issues facing the Justice Department: immigration enforcement, combating opioids, violent crime, protecting voting rights. And a lot of these are going to be discussed this morning. There'll be another oversight hearings. I first want to express my appreciation to Robert Mueller and his team for their service to our country, determining exactly what happened during an unprecedented attack on our democracy. We already know from their investigations 37 indictments that it uncovered serious misconduct, reaching some of the highest level, even if the President's involvement did not amount to a provable crime, and thankfully so. The American people and their representatives in Congress now expect to see the special counsel's work. And it's my hope that you're still committed to the greatest possible degree of transparency. As you know, classified material can be shared with Congress and is on a constant basis. But there's also precedence for sharing grand jury information as well, especially in high-profile investigations of keen public interest. In ongoing investigations, another reason to redact certain information, like all things in life, eventually end. One way or another, the vast majority of the special counsel's report will ultimately become public. I think attempts to hide swaths of the report from public scrutiny along the way will only fuel suspicions that have been raised by many that the Justice Department, which represents the United States, is playing the role of President Trump's defense team. For the integrity of the department, I know you well enough to know that you agree this is a result that must be avoided. Your imprint on the course of justice and rule of law in these moments are going to be scrutinized long after both you and I are gone from public service. The only way out, in my view, is transparency. You do have the discretion to release the full report to Congress. Nothing in the letter of the law stands in your way. So I hope in the coming weeks you will work in good faith with Congress to accomplish that. And Mr. Chairman, I will have a number of questions on the budget, and I appreciate the courtesy of being recognized.
You're welcome, Mr. Vice Chairman. Attorney General Barr, we're ready for your testimony. Thank you for joining us, and anxious to hear what you have to say.
Thank you, Chairman Moran. Thank you, Chairman Moran, and Ranking Member Shaheen, and Vice Chair Leahy, and members of the subcommittee. I'm pleased to be here today to present the President's fiscal year 2020 budget for the Department of Justice. I'm joined here today by the Department's Chief Financial Officer, Assistant Attorney General for Administration, Leigh Loftus. We're looking forward to discussing how our requested appropriations will help protect the safety and the rights of your constituents. Rather than read a statement to you, let me just say that I'm here to talk about the Department's $29.2 billion FY20 budget request. I believe the budget request supports our priorities. We're seeking $128 million of increases for our violent crime prevention work. We're seeking $291 million enhancements for our drug abuse and opioid efforts. We have $131 million for our national security and cybercrime efforts, and I'm seeking an additional $72 million for our immigration work. I'm proud of the Department's accomplishments and our workforce of more than 112,000 men and women, and I'm looking forward to your support for the resources we need for their important work. With that, I'm happy to answer any questions.
Attorney General, thank you for your brief statement, and thanks for the opportunity to ask you questions. I would just reiterate and ask for an answer to the question I raised in my opening statement. I was uncertain as to what you were conveying yesterday during your House testimony about whether you will provide a report of the report or a redacted version of the actual Mueller report.
Yes, it's my intention to provide the latter. As I said in my confirmation hearing, you know, the regulation under which we're operating did not contemplate and specifically was meant to avoid these public reports, but I feel I have the discretion in these circumstances to make the report public as long as it's consistent with the law. And as I said at my hearing, that I was going to try to be as transparent as possible, and that's what I've been working toward. There are 4 areas. I intend to release the report with redactions made in 4 areas, and they were specified in my March 29th letter. The first area is 6E material because, and I'm talking here, by the way, about the public, a report that would be available to the public generally, and then I'll talk a little bit about the report available to committees of Congress. The report I'm working on now, I would like to make available with redactions that would enable me to make it public generally, and there are 4 categories. The grand jury material, which by law must be retained within the department absent very specific circumstances, which I do not think exist here. Second category is any material identified by the intelligence community that would put at risk intelligence sources and methods. The third category is information that would impair existing prosecutions and investigations that are going forward right now, either by affecting the ability of the department to pursue them as effectively as we'd like, or being unfair to the individuals who are actually parties to that prosecution. You will recognize that Special Counsel Mueller did spin off a number of cases which continue in progress and are being handled in the department. And so we have to make sure that nothing in the report impinges on those ongoing cases. And the final category is information that implicates the privacy or reputational interests of peripheral third parties who were not charged. Now, the people who are making these redactions and implementing these four categories are the department working with the special counsel office lawyers, and those are the people involved in making the redactions. So, as I mentioned yesterday, we plan to identify very specifically which redactions relate to which category and try to explain why that redaction was made. I also said yesterday that when it comes to Congress, once I get this done and the public, everyone has the report, I'm willing to work with the committees. The regulation requires that, doesn't require, but it has my notification go to the judiciary committees, and I intend to take up with the House and the Senate Judiciary Committees, the chair and the ranking members of each, what other areas, they feel they have a need to have access to the information, and see if I can work to accommodate that. As has been correctly said here, the fact that information is classified doesn't mean that Congress can't see it. So I'm willing to work on some of these categories. The category I think is the most inflexible under the law right now is the grand jury material. But even there, once the redactions are completed, I intend to sort of read the report and see if there are areas where it affects the intelligibility or, really has an impact on the report. And I'm willing to work with the judiciary committees to see if there's a workaround that could address any concerns or needs that they have.
General, under the assumption that your answer was of interest to my colleagues, I'm going to continue with another question beyond my time. I want to talk about grant funding that's been delayed due to litigation surrounding sanctuary cities. So in the past, the department has tried to enforce federal immigration law by imposing special conditions or bonus points on recipients of federal grant funding. These conditions restrict grant funding to jurisdictions that certify they're in compliance with federal law, stating that they are not sanctuary cities or states. That's not something that I'm complaining about in this question. What I'm concerned about is the money that has been held up as a result of that litigation because of pending litigation in regard to burn JAG grant funds. We've had success in that occurring, but unfortunately that has not been the case in the FY18 COPS hiring grants. These solicitations were pulled and applicants are still unable to apply for COPS hiring grants going back to FY18 awards. Have you reviewed the department's policies? Is there a plan to figure out how that we can provide those necessary resources to local law enforcement to retain and hire law enforcement officers?
Yes, I think this is the problem is really a function of this phenomenon of nationwide injunctions that are imposed by district court judges, and this is actually a fairly recent phenomenon. The old practice in law was that if a district court judge issued a decision, the judge could redress the grievances of the parties before the court. But now courts are granting nationwide injunctions. As a result, if a district court in Northern California, which is I think the court that may have been involved here, grants an injunction, they enjoin the grant program nationwide. Now, one of the reasons we were able to, and Lee can correct me if I'm wrong about this, but one of the reasons we were able to get out the burn JAG grants was that there had been a district court in Chicago that had enjoined it nationwide. We went to the Seventh Circuit. They required the court to reduce its injunction just to its jurisdiction. And when that happened, we were able to get out the burn JAG grants. What's happened with the COPS grants is that it's enjoined by several district court judges. We're arguing, if not today, within the next few days in the Seventh and Ninth Circuit to try to have that addressed so we can get those grants out. But frankly, I think we need to come to grips with this issue of nationwide injunctions. because I think the way the system should do these issues should percolate up through various circuit courts and so forth up to the Supreme Court, and the idea that one district court judge can kill programs nationwide is a serious problem.
Thank you for your answer. If you're successful in finding a path to see that the COPS grants are available, please be prepared as a department to proceed quickly if and when that occurs. And I don't think local law enforcement has been able to even submit a grant application. So it is significantly delayed, and maybe there's a way that those grant applications, I don't know what the injunction covers, but maybe there's a way to submit the grant application even if you can't award a grant until you receive judicial authority to do so.
I'll look into that.
Thank you. Senator Shaheen.
Thank you, Mr. Chairman. And let me just echo what Senator Moran was saying about the COPS grants, particularly in states like New Hampshire, where we have no sanctuary cities. It's very onerous for us to be affected by these rulings. I want to go back to your comments about the 4 reasons that you intend to redact portions of the special counsel's report. The 4th one was information that would unduly infringe on the personal privacy and reputational interests of peripheral third parties. Does that mean that you will redact information to protect the reputational interests of the president?
No. I'm talking about people in private life.
Okay.
Not public office holders.
Thank you. News just broke today that you have a special team looking into why the FBI opened an investigation into Russian interference in the 2016 elections. I wonder if you can share with this committee who's on that team, why you felt a need to form that kind of a team, and what you intend to be the scope of their investigation.
Yeah, as I said in my confirmation hearing, I am going to be reviewing both the genesis and the conduct of intelligence activities directed at the Trump campaign during 2016. A lot of this has already been investigated, and a substantial portion of it has been investigated and is being investigated by the Office of Inspector General at the department. But one of the things I want to do is pull together all the information from the various investigations that have gone on, including on the Hill and in the department, and see if there are any remaining questions to be addressed.
And can you share with us why you feel a need to do that?
Well, for the same reason we're worried about foreign influence in elections. We want to make sure that during an election, I think spying on a political campaign is a big deal. It's a big deal. Generation I grew up in, which was the Vietnam War period, people were all concerned about spying on anti-war people and so forth by the government. And there were a lot of rules put in place to make sure that there's an adequate basis before our law enforcement agencies get involved in political surveillance. I'm not suggesting that those rules were violated, but I think it's important to look at that. And I'm not talking about the FBI necessarily, but intelligence agencies more broadly.
So you're not suggesting, though, that spying occurred?
I don't. I guess you could. I think spying did occur. Yes, I think spying did occur.
Well, let me.
But the question is whether it was adequately predicated, and I'm not suggesting it wasn't adequately predicated, but I need to explore that. I think it's my obligation. Congress is usually very concerned about intelligence agencies and law enforcement agencies staying in their proper lane, and I want to make sure that happened. We have a lot of rules about that, and I want to say that I've said I'm reviewing this. I haven't set up a team yet, but I have in mind having some colleagues help me pull all this information together and let me know whether there's some areas that should be looked at. And I also want to make clear this is not launching an investigation of the FBI. Frankly, to the extent there were any issues at the FBI, I do not view it as a problem that's endemic to the FBI. I think there was probably a failure among a group of leaders there at the upper echelon, and so I don't like to hear attacks about the FBI, because I think the FBI is an outstanding organization, and I think Chris Wray is a great partner for me. I'm very pleased that he's there as the director, and if it becomes necessary to look over some former officials' activities, I expect that I'll be relying heavily on Chris and work closely with him in looking at that information. But that's what I'm doing. I feel I have an obligation to make sure that government power is not abused. I mean, I think that's one of the principal roles of the Attorney General.
I certainly agree. I think we all have an obligation to ensure that government power is not abused. The question I have is what happens when the executive is potentially playing that role, and that's where it doesn't seem to me there has been adequate oversight. Thank you, Mr. Chairman.
Senator Collins.
Thank you, Mr. Chairman. Welcome, Mr. Attorney General. Last June, your predecessor, then Attorney General Sessions, announced that the department would no longer defend the Affordable Care Act's pre-existing conditions provisions because they were inseparable from the ACA's individual mandate. 2 weeks ago, your department went much further, deciding that it would not defend any provisions of the ACA. This puts at risk other important provisions in addition to protection for people with pre-existing conditions, such as the Medicaid expansion, dependent coverage for young adults up to age 26, and coverage for preventive services. Now, the individual mandate is a highly regressive penalty, and I've long opposed it, and Congress repealed it. But I disagree strongly with the department's decision not to defend the rest of the ACA. In a letter that I wrote to your predecessor last June and to you on April 1st, I made the point that the individual mandate can be struck down and severed from the ACA, while the remainder of the law can stay in place. And this isn't just my opinion. In 2010, the Chief Justice Roberts said in the Free Enterprise Fund case that under the doctrine of severability, that generally speaking, when confronting a constitutional flaw, we try to limit the solution to the problem, severing any problematic portions while leaving the remainder intact. In 1990, when you were head of the department's Office of Legal Counsel under President George Herbert Walker Bush, you authored an opinion finding that the president could enforce the remainder of the statute after an unconstitutional provision had been severed. I agree wholeheartedly with your 1990 opinion. What led you to take a different approach?
Thank you, Senator. When I visited with you before my confirmation, I promised you that I would personally take a look at this issue, and I did. And I studied it carefully, and I provided my views robustly within the deliberative process that was going on within the executive branch. As I've said, when the Attorney General is providing legal advice, I think the first obligation is to provide the advice that you think is the right legal answer and how you would decide the case if you were a judge, which is what was the advice I gave. But I also have said that if the other stakeholders in the executive branch and the people involved, the agencies and so forth, end up in a different place, as litigator for the United States, the Attorney General should be able to advance positions that he believes are defensible and reasonable legal positions, even if they are not positions that the Attorney General would adopt if the Attorney General was the judge deciding the case. In this situation, the ultimate decision was to support the position of the states, including Texas, and the decision of the district court judge. The rationale for that is that it is a defensible and reasonable legal position, given that that was the decision of the district court and the position of 4 justices on the original NFIB case who felt that if the mandate goes, the rest of the statute goes. I know there's an additional point there, which is the fact that Congress did take out the penalty from the mandate, and therefore should that act be viewed as essentially validating the rest of the statute. And those issues were debated, but at the end of the day, I felt that the position was a defensible position, and it was the decision of the executive branch.
I would just make the final point that Congress had the opportunity to strike other provisions and chose not to.
Yes.
Thank you, Mr. Chairman.
Thank you, Senator Collins. Senator Leahy.
Thank you, Mr. Chairman. Attorney General, thank you for being here. Over the decades, we've had a chance to talk at these hearings many times. Let me go back to the discussion of your March 24th letter, and you said the President did not commit obstruction of justice. You said that before any reference to Congress. Of course, you have the position that no matter the evidence, you don't believe a president can be indicted while in office. You said the mechanism is through the ballot or Congress, not our criminal courts. Did you have any conversation with the special counsel about why he did not reach a conclusion one way or the other on obstruction?
Yes, I did. And he also has a fuller explanation of that in the report that I'll be making available hopefully next week.
Did he express any expectation or interest in leaving the obstruction decision to Congress?
Not that he didn't say that to me, no.
So he said the obstruction decision should be up to you?
He didn't say that either. But that's generally how the Department of Justice works. Generally, grand juries are to investigate crimes, and a prosecutor's role at the end of the day is binary. Are there charges or no charges? Or is this a crime or not a crime?
I've had some experience in that field.
So I think you would agree with me. But let me say that I don't feel, I'm looking forward to explaining my decision that I briefly outlined in the March 24th letter, but I don't feel I can do it until the report is out, because I think the report contains a lot of the information that would give meaning and content to the discussion, and I really can't do it in the absence of getting it out. So I'm anxious to get it out. That's what I've been working toward. And well, I said I'd come up to the Hill as soon as the Hill will have me, which I guess is at the end of the month, to testify about that.
Well, to sort of follow up on something Senator Moran asked, and determining what should be redacted, have you overruled Mr. Mueller or his team on any redaction question?
No.
One way or the other?
No.
Okay. Have you discussed any specific redactions with the White House?
No.
I'm just curious, before this came out, you were at a sort of an annual St. Patrick's Day event at the White House with the Taoiseach, the Prime Minister of Ireland, exchanging shamrocks and so on. You had a long discussion, and apparently a very, you both seem very happy with the discussion, you and the President. Were you discussing the report?
Was I?
Yeah.
No, it was actually in front of several justices of the Supreme Court and numerous other dignitaries. I wasn't alone with the President.
Okay. You're sure of that?
What?
So anybody thinking they heard you say anything else would be wrong?
Right.
Okay. You've indicated you redact grand jury material, but of course in both the Watergate and the Ken Starr investigations, grand jury secrecy was overcome to allow congressional access. Have you asked the district court to release grand jury material to Congress?
Did you say, were you citing the Starr investigation?
And the Watergate, yes.
Okay. Well, the Starr investigation involved a specific statute that
Rule 6C? 6E, rather?
No, the Starr the statute setting up the independent counsel provided for the report going to Congress and overrode 6E. So I don't view the Starr situation as
well. But more specifically, have you asked the district court to release grand jury material?
No. The law right now is in the District of Columbia that the court can only waive 6E for one of the grounds specified specifically in 6E. There's no sort of inherent power in the court to do that. And if someone shows me and you know, I think makes a persuasive argument that it's covered, I'm willing to listen to that, but I don't see it.
And lastly, on a dollar amount, your budget, we're told from ATF, would result in could lose 370 positions under the president's budget, even though it shows a slight increase because of attrition and everything else. Are you satisfied with ATF at a time of violent crime and everything else losing these positions?
Are you talking about the 377 positions that Mr. Brandon mentioned?
I understood 370, but okay, whichever.
Yeah, we don't think he will lose those positions. There's some complicated accounting here that I'm sort of a little mystified by myself, but as I understand it, we've been continually investing and increasing the number of ATF agents, and they were worried about bringing on too many agents in excess of funds that were going to be appropriated, and they had sort of the way they quickly make up for that is to just take out head count rather than make cuts across the board. We don't think that they are, and Mr. Loftus here can give you more of an explanation if you'd want one. But let me just say,
my time is up, but I really would like more, because you can either do his 370 or the administration's 46. Either way, it looks very much like cuts in ATF.
I can add, Senator, just to say that ATF does have a 4% increase in this budget, and I have spoken with the ATF chief. I think he's an outstanding guy. I've worked closely with him over many years, and I do know that they are concerned about the resources in their budget, but we have looked at the 4% increase. We don't think the 4% increase translates into a loss of hundreds of positions, but we're willing to work very closely with ATF and make sure that we can protect certainly their agents. And again, any money that ATF receives, I think, can be put to very good use, and we look forward to working with both ATF and the committee on this one.
Senator Leahy, thank you. We have three votes scheduled at 11:45. My intention is to go until those votes are called, and don't anticipate coming back after that occurs. Senator Kennedy is recognized.
Thank you, Mr. Chairman. General, I don't intend to talk much about your budget. I think we both know that Congress will make sure that you're adequately funded. I want to talk a little bit about the Mueller report. I think it was inevitable that some people were going to be disappointed in the result, or results that Mr. Mueller reached. You can only be young once. You can always be immature. There will be some who were so disappointed in the result that they're going to attack the process in bad faith. I would strongly encourage you to ignore that. Just call them like you see them. Follow the law. Can we agree that if you turned over the Mueller report without grand jury material redacted to only members of Congress, can we agree that there is a material risk that the grand jury information would leak?
I think so.
I mean, that's been known to happen.
Yes, occasionally.
Yes, sir. In a sentence or two, why would that be bad?
Well, because we depend on the secrecy of the grand jury for our whole system of justice, and people have to be assured when they go into the grand jury that these are going to be confidential sessions.
I got it. Can we agree that if you turned over an unredacted report to the members of the United States Congress that included material that might impair an existing investigation or investigations, that there's a material risk that information might leak?
Yes, Senator, there's a risk.
Why is that bad?
Well, presumably the reason people are interested in seeing the report is because they believe it's important for the criminal justice process to work.
Yes, sir.
Allowing this other information to come out would frustrate, from the prosecutor's standpoint, the system from working in other cases, and from the defendant's standpoint would be unfair, potentially unfair to the defendant.
Let's talk about reputational risk. If you turn over a report...
Excuse me, Senator, could I just add something?
Certainly.
In some of these cases, there are gag orders from the court prohibiting this information from going out.
Okay. If you were turn over an unredacted report containing unredacted information that could raise reputational risk, can we agree there's a material risk that would leak?
Yes, Senator.
Why is that bad?
Well, it goes back to if someone has not committed a crime at the end of the day, and in this context, if they're not public office holders, they're private citizens, the government is not in a position to say they did anything wrong. It would be unfair, just fundamentally unfair, to put that information out.
Would that be especially the case if someone thought their communication was confidential?
Yes.
Kind of like Dr. Ford, who thought she was making a confidential communication until some member of the Judiciary Committee or their staffs turned her life upside down and leaked that.
I'm not aware of the circumstances myself.
I'm not either. I wish I were. It was probably the greatest injustice I've seen in the time I've been here. Let me talk a little bit in the minute I have left, and I'm going to land this plane on time, Mr. Chairman. I know you're taking a look at the genesis of the investigations with respect to the 2016 election. Just quickly, can we agree that the FBI is the premier law enforcement agency in all of human history?
Absolutely. And
can we agree that we want FBI agents and Justice Department members to have thought about the world, thought about socioeconomic problems, and thought about how to solve those problems? You don't want a dummy working for the FBI or the Justice Department, correct? But they're not supposed to act on those political beliefs, are they?
No, Senator.
It appears to me, I'm not going to ask you this question, that there were a handful of men and women at the FBI and possibly at the Department of Justice who did act on their political beliefs in 2016. Some of them were for Donald Trump. If you don't believe me, ask Secretary Clinton. Some of them were for Secretary Clinton. If you don't believe me, ask President Trump. And that's not right. And we need to stop this from ever happening again. my plane has landed.
Thank you, Senator Kennedy. Senator Reed.
Well, thank you very much, Mr. Chairman. Thank you, Attorney General. Let me return to your March 24th letter to the Judiciary Committee and along the lines of Senator Leahy. You quote the special prosecutor, the Director Mueller, with respect to the allegations of obstruction of justice, and you say, while this report does not conclude that the President committed a crime, it also does not exonerate him, which raises a question in my mind. Did the special counsel find probable cause that a crime had been committed?
I'm not going to characterize his report. The report will speak for itself, and that's why I want to get it out.
Well, then let me just follow up.
But I think my letter says that he did not find a crime was committed.
No, I understand that, but it's, I think, important to note that you took his language and said, I did not find a crime, but I can't exonerate the President. That suggests that there's a possibility that probable cause existed for a crime. However, someone, either Director Mueller or yourself, made a determination that the evidence would not be beyond, could not convince a jury beyond a reasonable doubt, or that the policy of the department was not to charge the President because of the constitutional issue of impeachment. So this is again, I'm trying to understand why not only Director Mueller said this, but you repeated it, that the President was not exonerated from the obstruction of justice allegations.
As I explained yesterday, I was trying to state just the bottom line conclusions and not characterize it or try to summarize the report beyond just stating its bottom line conclusions. And I thought the best way of doing that was taking that language from Mueller's report.
Well, let me sort of turn the question around. If there was no evidence probable cause, then I would presume he could have said very clearly that there was no crime committed, that he could in fact exonerate the President, as he seems to have done with the allegations of conspiracy between the campaign and Russia.
I think that sentence says he didn't find, he's not finding that there was a crime, and he's not exonerating. I'm not going to sit here and try to characterize his reasoning or his report. That's why it's important to get the whole report out instead of trying to read these little teeth.
No, I absolutely.
Probable cause is a very low standard for determining when you start investigating something. A lot of things have probable cause.
I understand that, but I think it's important. I agree with you completely. It's important to get the whole report out to the American public, because there are serious questions that we've just gone back and forth on, and your response, I think, is very critical. Those questions aren't going to be resolved until the American people see this report, not sections of it, not paraphrases of it, but this entire report. Let me just quickly ask another question, which is, do you have any specific evidence that there was anything improper in the counterintelligence investigation by the FBI, or anything improper in the way the investigation was carried out by the special counsel with respect to the 2016 election? Do you have any evidence?
I'm sorry, there was a compound question.
Compound question. There was a counterintelligence investigation by the FBI with respect to the 2016 election involving primarily the Trump campaign. There was the investigation by Director Mueller into the 2016 campaign and other issues. Have you any evidence that there was anything improper in those investigations?
I have no specific evidence that I would cite right now. I do have questions about it.
So this panel you're putting together is...
I'm not putting together a panel.
So you just have some interest in this. You don't have any evidence?
I have concerns about various aspects of it.
Do you believe that the investigation that Director Mueller undertook was a witch hunt or illegal, as been asserted by the President?
As I said during my confirmation, it really depends on where you're sitting. If you are somebody who is being falsely accused of something, you would tend to view the investigation as...
Well, you're sitting as the Attorney General of the United States with constitutional responsibility, so if you could answer in that regard.
Well, I'm not going to characterize it is what it is. You know, Mueller and his team conducted an investigation and are issuing a report. I'll use my own adjectives.
You can use your own adjectives, and those I don't assume include witch hunt or illegal. Is that correct? Those would not be in your answer.
I haven't referred to the.
Thank you very much. Thank you, Mr. Chairman.
Senator Murkowski.
Thank you, Mr. Chairman. Mr. Attorney General, welcome. I want to start my questions with the issue of marijuana. Senator Gardner has really taken the lead on this issue over here in the Senate. I have been supportive of his efforts. He's trying to move forward with the States Act. I'm co-sponsoring that. But when we visited and during your confirmation process, you explained that you believe that the current conflict between federal and state marijuana laws is untenable, was the words that you described. You also explained that you will not upset settled expectation or the reliance interests that have developed because of the policies from the prior administration. But you did state that you believe the current situation really has to be addressed. I know and understand that you don't support the wholesale legalization of marijuana. You made it clear that we face a binary choice between the federal prohibition and a, quote, federal approach to correct the disconnect between federal and state marijuana laws. And so I think you committed to me and to others that this is something that Congress has to address the right way, which is through legislation, and we would agree with that. We think that the States Act is an approach that does what you have recommended. It adjusts the federal law the right way to create a federal approach to marijuana. I think the President has expressed some support for it. So can you share with me, share with the committee, where you are on this approach that has been outlined in this States Act, and whether or not we can work with you on this issue?
Yes, Senator. The situation that I think is intolerable and which I'm opposed to is the current situation we're in. And I would prefer one of two approaches rather than where we are. Personally, I would still favor one uniform federal rule against marijuana, but if there is not sufficient consensus to obtain that, then I think the way to go is to permit a more federal approach so states can, make their own decisions within the framework of the federal law. And so we're not just ignoring the enforcement of federal law. Now, I haven't studied specifically the state's law, but I've just circulated it through the department for comment. I think that's the process it's in now. Once we get those comments, we'll be able to work with you on any concerns about the state's law. But I would much rather that approach, with the approach taken by the States Act, than where we currently are.
Well, I think you'll have a group of folks over here that would like to work with you, would like to work with the department on that. Let me move to VAWA and Special Domestic Violence Criminal Jurisdiction. In the 2013 reauthorization of VAWA, we recognized tribal special domestic violence criminal jurisdiction that allowed tribes to prosecute non-native domestic violence offenders in tribal courts, and this was for a limited class of offenses. So just last week, the House passed its reauthorization vehicle that expands this jurisdiction to a broader class of sexual assault and domestic violence offenses, as well as crimes against children and assaults on tribal police officers. The vehicle there, the reauthorization vehicle, also allows for a pilot project that is specific to Alaska Native villages that have 75% or greater Native population to exercise this jurisdiction. I think that all these provisions in the House bill are a step in the right direction. You and I have had discussion about the issues of just protection in general in outlying areas of very remote parts of my state, where we really have got to be thinking outside of the box when it comes to how we provide for protection. And so allowing for these limitations based on jurisdiction are really, really hard when you have women and children that are vulnerable. So I'm hoping that we can continue to work with you on these jurisdictional issues. I'm hopeful that we'll have a chance to bring you up to the state so we can get you out into some of these villages, see how these tribal courts are functioning, and again, better explore the opportunities to provide for a level of safety. I do appreciate you including the 5% tribal set-aside from the Crime Victims Fund. I think that this is going to make a difference. But if you can comment in any way on this aspect of tribal jurisdiction and what it might mean for domestic violence protection.
Well, I think Alaska Native women, face unacceptably high levels of violence in very remote areas, and I've actually scheduled a trip up to Alaska specifically to visit some of these communities. And so I would approach this with a great deal of sympathy for the need to think outside of the box and to do something that's effective in protecting this vulnerable population. And I'm prepared to work with you to try to fashion something that will work.
Well, I appreciate that, and also working on the murdered missing Indigenous women's initiatives that we're working on. I look forward to that as well too, and welcoming you to the state. Thank you, Mr. Chairman.
Senator Manchin.
Thank you very much, Mr. Chairman. Thank you, Mr. Attorney General, for being here in your service. I'm only going to say one thing about the Mueller report. I would just compassionately ask the more that you can reveal. If it doesn't interfere with a criminal investigation or with intelligence that we need to protect, the more you can do, the more healing will happen for our country. I believe that would be very, very, very helpful. So I hope you would consider that when you're releasing your report back to us. The other thing I wanted to say is on